Hello, everyone. We wanted to welcome you to a regulatory discussion. I think we'll do a quick introduction, but to give you a preview, we have entitled this Regulatory Confessions. And it's a little bit spicy in parts. But my name is Chrissy Hill, and I am the Chief Legal Officer and Interim Chief Operating Officer for Parity. To my left.
Hi, I'm Josh Klayman. I'm U.S. Head of FinTech and Head of Blockchain and Digital Assets at the global law firm Linklaters, and I have the great pleasure of working with these ladies.
And what I always say is that Josh is my partner in compliance, not my partner in crime. So Josh and I worked together on the SEC process for the Web3 Foundation back from, starting in 2019, over 3 years. I'm the founder and CEO of Signal Growth Capital, and I am now the co-founder of Play, which I'm really excited about.
And as a quick side note, when I was looking to join Parity in 2021, I, of course, was very interested in what was happening on the regulatory side and who was leading us, who was advising us. And when I found out that it was Josh and Angie, I thought, this is a fantastic team, and what a privilege it is to join, because we are very fortunate that they've been leading the discussions with many regulators, including the SEC, since 2019, 2020. So we wanted to share with you some of the recent discussions that are going on that were generated by Alison Bob's report, which have actually caused a little bit of deja vu, particularly for Angie and Josh on the regulatory front. And to set the scene a little bit, after that report went out, James Seifert, who is a Bloomberg reporter who's been leading the discussions on Bitcoin ETFs and Ethereum ETFs, basically tweeted about that report. And he started off the discussion saying, warning, this 5-word tweet is triggering for some. What was that 5-word tweet? Sounds like a common enterprise. Now, y'all may be asking yourselves, why would those 5 words be triggering? Why was he going out to make these comments in, again, a bit of a controversial way? What was he hoping to generate? So I think this is a good time, Josh, for you to maybe give us a little background about why common enterprise, a seemingly innocuous term, would be triggering to some.
Thanks, Chrissy. So I think also just stepping back for 1 second, as you may know, originally this was Regulatory Rhapsody, and we were going to cover a whole bunch of things, but we thought that this was so important and a great opportunity to kind of share with you some of what we've done over the years, just to bring you into the circle a bit more. That's why we're focusing on it and not on the longer list of things that originally we'd talked about. So why it sounds like a common enterprise? Why does that even matter? Well, the place where common enterprise comes up, it's in the age-old Howey test, which many cringe when they hear about, but it's the US's test for whether there is an investment contract, which is a form of a security. And it's a 4-pronged test. It asks whether there's been an investment of money in a common enterprise with a reasonable expectation of profit based solely or primarily on the managerial or entrepreneurial efforts of others. So did you invest money thinking that someone else was going to grow something, then you were going to get a profit, basically? And why was it triggering? Well, on one hand, you could say, well, maybe it shouldn't be triggering because it's just one of the prongs and you have to have all 4, right? But we thought it was a bit triggering, and many thought it was a bit triggering because it's sort of baiting whether, in some people's view, are they trying to say that the DOT could be a security? Right? And so that's exactly what we wanted to address.
Mm-hmm. So I'll just take us back to 2019 when the SEC said, come in and talk to us. We thought that everyone would rush in. Having had, so I have a 20-year background in traditional finance and kind of working with emerging technology companies, especially in video games, and regulators are just part of the process. And so I never even thought that people wouldn't go in and talk to them. It turns out that Polkadot was the only, protocol that did do that. I mean, there could have been others, but it felt like we were alone in that process. And what we did was we dug into what already exists within the SEC, and we found three things: the or the framework for investment contract analysis for digital assets, the Telegram case, which was just out, the conclusion of that by the SEC, and the Dow Report had already come out that discussed, and this is very important, discussed a DAO which issues a token is something that could be unlawful. Now, part of the reason why this is a big discussion and the reason why there was a lot of confusion last week is because the DAO, the Polkadot DAO, did not issue a token. Unlike most DAOs that we've seen, I don't know if there is a DAO that did what we did. What we did is we looked at that guidance that already existed, and we concluded, based on the guidance, that the token, the DOT token, which again was not issued by the Treasury didn't exist. It was issued by the Web3 Foundation. And it must have been delivered, we determined, as a security. Only after the delivery of the DOT token as a security could it go through the process of decentralization, which was referred to at the time as morphing. So the Web3 Foundation, as Fabi said in his tweet, issued the token, and then over 3 years, or less than that, but the decentralization process was completed. Every part of the white paper was delivered, and then we determined at that point, through Josh's legal opinion, that the DOT token was no longer a security, that it was simply software. So that was the process that we went through. Also, very importantly, as part of that process, we presented to the SEC the idea of a decentralized treasury, because that didn't exist at the time. And it was a very interesting topic to the SEC, one that we spent a lot of time explaining. And I would love for you guys to jump in, but I'll go ahead and just, this was an email just to take you back to 2020, an email that only Josh shows up. There are other people on the email that I removed. So it was Casper Jurgensen at the time, who might be here, was the CFO of Web3 Foundation, and Josh and I were in constant discussion with the SEC, and this process included not them telling us what to do, but us, again, reading into what had already existed and coming up with ideas to present to them. So we said, we still believe that the on-chain treasury truly differentiates Polkadot as an additional point of decentralization that other chains simply did not consider. And then I'll go, we talked about the fact that other chains were more like centralized actors that provided grants. And then we said when developing Polkadot, the founders saw an on-chain decentralized treasury concept as a significant improvement relative to existing chains, which were centralized and off-chain. And then this next line I should have highlighted because it's very important. We've built an on-chain funding mechanism that is the size of many venture capital firms and does not require any central party. So this concept is very important for everyone in the Polkadot ecosystem to understand, because this is what differentiates Polkadot. So the triggering might be triggering to people outside of Polkadot because they don't understand that we did this differently.
Yeah, and may I just jump in for 1 second, just about going back to the Dow report and what that was focused on. So Angie talked about a DAO that had issued a token. That was a very different situation. In connection with that fundraising, the whole point was for people who got tokens to be investors in a virtual venture fund, right? That was the entire thing. So it was the paradigmatic example of what a security might look like, at least in the SEC's eyes. Whereas this is very different, and this is styled as Polkadot Confessions because this was not something that was hidden. This was actually put right to the fore in discussions with the SEC and was a key part of the journey towards decentralization, right? And the journey towards no longer being classified as a security or a securities transaction.
And can y'all tell us, this email is from 2020, right? 4 years ago. And obviously, a lot has happened during that time. But can you tell us a little bit about that education process, like the dialogue that you engaged in with the SEC, and maybe some of the questions that they asked that you think now, look, we had such great foresight?
Sure. I mean, maybe one thing I'll just say is the framework that Angie mentioned, and Chrissy, I believe you may have mentioned it as well. What that was at the time, it was SEC guidance. It's still out there. It hasn't been repealed, right? Where they said this is how we think about the Howey test as it applies to digital assets, right? And if you look in that framework, there are a lot of references to things called active participants, right? So who are we looking at? Who is going to be guiding everything? Is there a guiding person or set of persons? Is there someone propping up the token price, things like that? And so thinking about having a decentralized treasury, that is a move away from having just a sole source of funding for the ecosystem. Not that you couldn't have other sources, but in terms of one of the things the SEC was very interested in, and Angie can go through it in great detail, because I think we have a slide about it too, is really like, okay, so grant funding by the foundation versus grant funding by this decentralized treasury. And so, again, far from being a point that was not discussed, this was a key point of discussion in terms of milestones and the further decentralization of the ecosystem.
Mm-hmm. Yeah.
Next slide.
Yeah, I think it would be good to go through one of the questions. This was around the decentralized treasury that we discussed with them. And again, this is before the launch of Polkadot. So one of the questions from the SEC was, could there be a point at which this on-chain treasury that you're talking about could actually be larger than the Web3 Foundation in terms of providing grants? And what could that crossover be? So we modeled out for them, what it might look like based on inflation, based on slashing. We made a lot of assumptions, and we said, in fact, if you look at the on-chain treasury right now, it's at 39 million, compared to the portion of the Web3 treasury that is allocated to grants, which was 20 million. And again, all of this was kind of in early launch mode, and we said if the Web3 Foundation continues to offer grants at the pace they're offering them, the on-chain treasury could be much larger. And it's all going to depend on, kind of activity in the network and, applications that are being built. And, we gave them a set of assumptions, about 15 assumptions, and we showed them kind of the growth that we projected of the on-chain treasury. And at the time, we said, look at it now, it's already larger. And then the second point we made, Chrissy, can you go to the next page? The second point we made was that, it was larger, but it was a little bit larger, and there still wasn't really awareness at the time around how people could apply for grants. We thought we're going to have to go through education. What is Polkadot? How can we integrate it into applications? And we felt that it could happen quickly. Now it has ramped, as we all know, over time. But a really important concept that we presented to them repeatedly, I would say,
Yes.
is this is a completely new concept. We could see software developers who have really good ideas applying for funding for their companies. We were talking about this like it was completely new because it was. We would say they would apply for funding to this decentralized treasury where all of the participants who hold DOT vote, and then those entrepreneurs are working for Polkadot as if Polkadot is their boss. That's how we would describe it to them at the time. So again.
And that's how we did describe it.
That's how we did describe it, as you can see in the email. So all of this came to fruition, but nobody else has done it this way, which is why we think, again, might be triggering for those outside of Polkadot, but to us, it was by design.
And I think, obviously, we have done things a particular way, and other protocols have chosen to do things differently. But I think one of the interesting points of discussion that we've had is that it's great to see all voices being represented, the laws being tested, legislation being requested across the world, not just in the States. So, just for the audience, of course, we're pointing out how we're different, but, if you believe in Polkadot, you believe in a multi-chain world, having as many voices as possible working together across the industry in order to have certainty for the industry is really important. So, we're not obviously saying that others have done things wrong. We're saying they have done them differently, and there is a lack of certainty. And so that's why the industry working together, we want to be able to come to a conclusion where, for instance, whether you like the regulation or not, at least when you go into a particular jurisdiction, including the US, that you can build that into your budget, right? It's not going to be an unknown legal cost associated with potential litigation or taxes. It will be clear from the outset, which is important for everyone running a business, regardless of what sector you're in.
I would love for Josh to go through the idea that she talked with us about in the early days, which is the easiest path is the path that already has been plowed by regulators to date, not fighting them with a new path, but what have they already given us to work with? Can you just talk about that? Because the technology, we have to continue to point out the technology is the most important thing, was the most important thing at the time. We were just looking for the shortest, easiest route to not be in a security. Go ahead.
Exactly. And I think just sort of also just touching upon what Chrissy said for a moment, this isn't about regulatory moat building. Like that's not the goal at all. It's more in terms of our even describing this, it's mostly because of what was a perceived, attack or question, right? Where we thought, hey, it's important to show people, actually, no, we did think about this. And we actually were explicit in our description to the SEC about what this might and would look like. So yeah, if we go back in time, right? Not talking about now where there are litigators fighting the good fight, there are people with regulatory outreach and policy, legislative outreach, all sorts of movements and new case law decisions every day. I think at the time, just going back, as Angie had said, Telegram had just happened. And what happened in Telegram? I know there's activity happening on that blockchain now, right? But at the time, the grams were not delivered yet, right? We were waiting for grams, we collectively, the world, were waiting for grams to be delivered, and the SEC prevented that, right? They prevented that not just in the US, but also outside of the US. And so that was scary for a project that had, really important tech that needed to be delivered, that was important for the whole, Web 3.0, right, to be delivered. And that would help usher in and continue this multi-chain world. So I think with that, we looked at what the guidance was, and the guidance that we had was the April 2019, so if you go back in time, that was new guidance at the time, which really talked about, the SEC's describing how it applied the Howey test to digital assets. And many people look at it and say, it's just a bunch of factors. They almost all say that you have a security. And guess what? They have a few factors in there, though, that say, well, if you start out with a security, here's how you get to a non-security. And so that's the path that we took. And I will just say, there's a lot of talk now about secondary sales and, whether secondary sales should ever involve the sale of a security when it comes to digital assets. And certainly new law is being formed and great scholarship has been done. I will say that is an approach we tried, right? We did try to say like, hey, look, we're going to deliver it pursuant to this securities law exemption, which DOT was sold pursuant to a securities law exemption. We're going to deliver it. And then the next hop, when it goes to another person, it shouldn't be a securities transaction. We tried that, so we're not knocking it, but it just didn't fly. And so we went with what flew, and it did fly. And we got to a good result. And it took time, but yeah, I mean, that's the best way I would say. We are not fighting against other approaches. In fact, we tried to take some other approaches, but this is the one that worked.
And the
for
only,
us.
I would say also that we did go down the path of Regulation S. So the way to think about, issuing a token, there are exemptions from, in traditional finance, if a company is considering going public, they're going to register, right? That would be a kind of a traditional path. That's really not possible in crypto under the current laws. So a second path, well, I shouldn't say that's not possible. I'm not a lawyer. Josh is a lawyer. She'll probably correct me on that. But generally,
depends.
it's not, what?
It depends.
It
Like,
depends. But generally in crypto, it's not a path that that anybody I've seen takes. On the qualifying for an exemption from registration, there are exemptions that exist. And as far as we know, there is, there's an example also, I should say, Stacks did a Regulation A transaction. That's the only one that I know of that's like that took that path of Regulation A back in 2019, I believe, or 2018. And then we went down the path of Regulation S as an exemption from registration. And what that means is the issuance had to occur outside the U.S., completely outside the U.S., and it had to, we had to deliver the token to the original purchasers, all of whom were outside the U.S., and we went to great lengths to prove that. We had to, the tokens were locked for a certain period of time, which Josh determined, and we discussed with the SEC. The process of a Regulation S is to engage with the SEC on that process. So we believe at this time that we are the only protocol that did go down that path of Regulation S. So we're pretty proud of that because we concluded after a lot of the back and forth and analyses that Regulation S was a viable path to go down. And as far as we know, we're the only ones who've actually done it.
So I would just, if it's okay, if I can just add on to that
Yes.
slightly. So there are, I would say, like, if we look in all the filings, like there's at least one filing where someone filed an F1 to go public for a token, but that was a very equity-like security, right? It was an
Expressly as security. Yeah.
And what I think is important is it's possible, and I think some people do restrict their token sales to only those outside of the US, but a key part of that has to do with something called SUSME, so substantial US market interest. And that's the piece that I think is so critical, is not marketing the sale of the token into the US, right? There were steps that were taken in connection with the Reg S that was done that involved things that were highly unusual at the time and often highly unusual in general, right? An NDA and certain other steps, certain wireframes saying where you're located in the world, right? Plus geofencing, geo-blocking, but really policing communications. Because one could say, oh, I'm only selling outside of the US, and yet on the other hand, be engaging in the US to try and create a public market. And I think, the Web3 Foundation was very disciplined in terms of really trying to walk the talk and restrict that. And certainly, after a period of time, the token did enter the US market. But again, that was not through the efforts of the Web3 Foundation. And I think that's important to remember.
So y'all have taken us back to 2020. And now we've got 5 minutes left, so we should fast forward, I think, a little bit to today. And just go back to that tweet from James. By the way, we did, all three of us, message him to invite him to join this discussion. I don't know if he's in the office or might be watching. In a few words or a 5-word tweet back, what would we say to that comment about being a common enterprise? What would you guys say about what's happening from that regulatory perspective in the U.S. today? What we've already said.
Yeah, I mean, I think, one of the things is, holding aside whether it is a common enterprise, being a common enterprise isn't enough. You know, that's not the Howey test. That's just one piece of it. And guess what? There were no investors in this treasury, right? The treasury was funded through grants. It was funded through fees and slashing, right? There aren't investors who are receiving a gain based on the activities of the treasury. So yeah, I don't know if I'd put all that in a tweet.
I have 8. I have 8 words that I want to
8
tweet
words?
back.
Yeah.
Okay, I'm gonna go with 8. Sorry, I had to count them in my head. The Polkadot DAO did not issue a token. That's my tweet back.
That sounds great. Short and sweet.
I think that's great. And I think all of, everyone in the ecosystem should have an understanding for why that is something we should be proud to say. Much like I think the report is something we should be proud of as well, because I think we're setting the standard as a protocol for transparency. I think that is something that is admirable, and many regulators are actually pointing to as something that they would like to see from others, because although we are not legally, there is no one legally obligated to make that disclosure to token holders. Ethically, it's the right thing to do. And I think it points a lot to the discussions around decentralization, a lot of the thought that has gone from the very beginning, from 2019, that y'all put into the regulatory approach, setting, the path that we're on now that has led to today, and then you can look back and share some of these Polkadot confessions. Are there any final points you wanted to leave the audience with today from a regulatory point of view?
I'll let you have the last word, Josh.
I mean, there's so many. There are so many updates every day across. I mean, if you remember back to our original agenda of the things we're going to cover, I mean, they're all relevant. So hopefully we'll be coming back to you with more updates.
We took the path that we felt that was available to us back then, and today, would you take a different path?
I mean, I think we took a safe path, or the safest path that was available to us. And I feel good about where we are. And I think, I guess we'll see what case decisions come down. But as of right now, I think we did the right thing. I mean, in any event, we got a good result, right? So.
Absolutely. And we are still, we focused on the U.S. Obviously, we're focused on MiCA. We're focused on global regulation. That's a whole separate talk. We did promise Disco Dow, MiCA minuets, but I think we've delivered on the sonatas of the SEC. So thank you very much, everyone. And if you have any questions, please do ask these ladies. They're here.
Thanks, Chrissy.
Thank you.